The first thing to say, so everyone's aware, is that we're going to record this meeting as per usual, like we recorded the last one, with the idea that we'll post it on the School of Law's YouTube channel. So if anyone is a bit uncomfortable with that or doesn't want to be recording if they ask a question, please make that clear and we'll make sure that's edited out from the final version. So that's just to make you aware of that. I think that seems to be okay. I don't see any objections to that. So the recording's started. So we've got a great group of speakers who are going to try and unpick the concept of ecocide in different ways and from different perspectives. And that's really, I guess, some of you who were at the opening panel of this series of two, the Politics of Ecocide law, will know that we began to do that in that discussion. And so we go a bit deeper, I think, with some of the speakers, and also a bit broader. We have a really broad range of perspectives. And I want to just take some time to introduce the speakers at the outset. We have, first off, we have Marília de Nardin Budó, who's Associate Professor at the Center for Legal Studies in the Universidad Federal de Santa Catarina. She's conducted important studies on the victimization of workers exposed to asbestos, and of the systematic attempts on the part of mining companies to mask and distort the effects of asbestos and limit their culpability. Recently, she's worked on the Brumadinho dam disaster of 2019 and a range of different studies of what might be broadly known now as green criminology. Indeed, Marília is the editor of the first international edited collection on green criminology in Brazil, Introdução à Criminologia Verde. I'm very, very sorry for my pronunciation. I'll just say that now. But you're very welcome, Marília. Thank you for coming. Following Marília, we have Tameka Samuels-Jones, who's Assistant Professor at the School of Administrative Studies in York University, Canada. And Tameka's research is on a range of topics relating to environmental crime and regulatory law. And I would say is at the heart of new debates on the kind of interface of coloniality, racialization, and environmental harm. For example, key studies on toxic colonialism in US territorial islands, fascinating study, geospatial study of environmental crime in US territories. And her other study, just to pick another example, Green Crime on the Reservation, which was a study of environmental harms on US Native American reservations. So you're very welcome, Tameka. And yeah, I'm kind of, we had some technical problems earlier, but thankfully we've got over them. So it's great to have that. Next up is Alexis Alvarez-Nakagawa, who is he's playing at home. He has a faculty strategic lectureship in law in this school at QMUL. And his work is on the intersection between human rights, legal theory, and environmental justice. Hello? Yeah, I forgot to say at the start, could people please mute when they're not speaking? Thanks. I think that's Tiago. I think maybe Tiago accidentally is, yeah, but yeah, I can see you're muted now. Okay, sorry, Alexis. I'll continue with your biography. So Alexis has published key works on international law and the colonial relation and on transitional justice, as well as looking at the attribution of legal personhood, more recently, the attribution of legal personhood and rights to non-human beings in different jurisdictions. Alexis has held a Leverhulme postdoctoral fellowship and a Max Weber postdoctoral fellowship, the Leverhulme one here in QMUL and the Max Weber fellowship in Florence at the European University Institute. So you're very welcome to be playing at home here, Alexis. Great to see you. Next up, Jose Atiles, who's an assistant professor of sociology at the University of Illinois at Urbana-Champaign. He's worked at the University of Massachusetts, Amherst, and the University of Puerto Rico, as well as for many years as a research fellow at the Center for Social Studies in the University of Coimbra in Portugal. Jose is very well known, one of the most prominent scholars of the colonial relation between the US and Puerto Rico, and has focused on the political, legal, philosophical, and more generally the neo-colonial implications of that relationship, the uses of law and exceptionality, the criminalization of Puerto Rican struggles, anti-colonial and political struggles, and more recently on the role of corruption, particularly in relation to Hurricane Katrina, and also has been developing those themes through an understanding of environmental harms, and has published numerous articles and books on those subjects. Great to see you here, Jose. You're very welcome back at QMUL. Finally, we have Hannah Meszaros Martin, an artist, filmmaker, and writer based in Goldsmiths, indeed as a research fellow at forensic architecture at Goldsmiths. We are huge fans of what forensic architecture does. And if people here don't know, you need to look them up and see all of the kind of important and interesting political and artistic engagements that they're involved in. And Hannah's at the center of that. She's been a member since 2012, has done major projects in Colombia, Mexico, exhibitions in Berlin, Barcelona, and more recently, fairly recently, I think, in Bogota. And one of the reasons we were really keen to have Hannah here is that she's published what we regard as important work on the way in which the US-led war on drugs in Latin America acts as an ecocidal force. So it's great to see you here, Hannah. You're very welcome, as is everyone. So without any more detail on our speakers, I think we have enough. I'm going to turn to the first speaker, Marília. You're welcome, Marília, in your own time.
Thank you. Good afternoon to everyone. I'd like to start thanking the organization for this invitation. I'm glad to be here, listening, learning, and participating in the debate about this so crucial subject. For getting started, it's important to situate myself. I am a white Latin American woman based in Brazil who studies state corporate crimes and environmental victims. I originally come from the field of Latin American critical criminology, and I am also a lawyer. My perceptions on the topic Rethinking Ecocide will come from this place I am situated. I am following the debate about the criminalization of ecocide with special interest. In Brazil, there is already a bill being discussed in our parliament to also introduce it in our internal law of environmental crimes. I want to share with you today some of the reflections we are doing in this scenario. One of my main interests in research is to comprehend the mechanisms of naturalization and denial of death, not only of people, but also of other animals and entire ecosystems by powerful agents. When I say death, I am talking about the life loss that goes beyond its only biological meaning, comprehending its historical and cultural meanings too. As we know, environmental destruction nowadays is massively caused by the paradox between the voracious search for profits of the capital and the reproduction of nature. However, it is also true that racism, androcentrism, and coloniality are structures of oppression that differentiate the bodies and territories deserving a healthy life from the disposable ones. When I say that I am interested in the life loss in its historical and cultural meanings too, I am referring that colonization is about knowledge too. As Quijano says, the coloniality of knowledge has been historically produced to legitimize and naturalize all types of violence against the others of modernity. The others were always considered to be the object of intervention and research and have never had the chance to speak about their perceptions about their way of life and relationship with nature. The same people seen as the others by modern rationality are the most affected by environmental harms and the less responsible for them. They are women, non-white people, and mainly they are based in the global south. And at a global level, this is expressed, for example, by the migration harms from the global north to the global south, the double patterns of safety and regulation used by transnational companies, and the disputes for territory in which sometimes these companies engage. From this background, I would like to contribute to the debate, bringing some points. First, the importance of a grassroots movement to fight for environmental justice. Two, the criminological contradictions in focusing this movement on the criminal justice system and the modern penal rationality to deal with ecocide. And three, the epistemological contradictions about the concept of ecocide. So first of all, the movement Stop Ecocide is an important and global organization that is amplifying the debate around the climate crisis and of course promoting awareness about that. It's impressing the capacity of global mobilization, even if it's still more concentrated in global north. It is present nowadays in many countries, involving people from diverse spheres, and it's an example for global mobilization that must be acknowledged. So the questions I will raise are not to delegitimize in any sense it. My question is about why centering this so important force of civil society in criminalization. My first question comes from the field where I am situated. In the article Racial Borders of Genocide, the Brazilian scholar Ana Flausina explains that the Genocide Convention was inspired by the notion that human groups must be physical and culturally preserved. However, the convention that defined genocide was the result of relations of power, expressing the political interests of powerful nations. The original definition of genocide by Lemkin englobed the social, economic, cultural, and political destruction of the collectivity. At the end of this legislative process, the definition was considered too broad and a threat for sovereignty. Flausina says that the strict definition of genocide had as an important consequence the complete impossibility of making, for example, the United States accountable for the terrible discriminatory policies against its national minorities in the 70s and the 80s. The same country perpetrated many new colonial or imperialist policies in Latin America that could be considered genocide in the regional sense. In fact, it shows how it's difficult to avoid the recurrence if white supremacy is behind the law. Coming to the International Criminal Court, I think that everybody knows here the main arguments that delegitimize it. If you go to the ICC's website in the page Defendants, the images you see show the elephant in the room. There is an obvious question of coloniality and racism that is missing from the international debate. There is a color blindness about the hierarchization of bodies and territories that naturalize the fact that there is a visible tension about the possible racial combination of the status of victims versus defendants. Clearly, genocide is employed to reinforce the habitual stereotypes, especially between those who are racialized under the same category. When the representatives of the white elites just can't fit in the patterns of defendants, it seems that the white supremacy systems are not being challenged. This is whiteness. How can we just close our eyes to this as if environmental destruction was not also related to coloniality and racism? So this is the first point, like how to learn about genocide and the actual work of ICC to discuss ecocide. Second, my second criminological question is that the word stop ecocide bring an idea of prevention. Criminal law does not have empirical verifiable preventive effects. I understand that the arguments that in the international law, we can see more symbolic effects than in internal law, for example. The problem with this is what are we symbolizing? We have lots of soft laws in environmental issues that, of course, are really important. They have a symbolic effects and they are used for making pressure to governments. The question is what the ecocide law would really add to this tradition of symbolic effects in international law. Beyond the symbolic effect, its main possibility of use as an instrument is to provide selective punishment after that the harm was already perpetrated. What we know about the criminal justice system is that it is a tool to selectively manage the illegalities where the binomial crime penalty blurs the real conflict behind those terms. In this sense, where we see a crime of ecocide, we don't see its actual causes, the structure behind it. And because of this, there is a huge probability that the harm will be perpetrated again and again. So my third question is epistemological. The response with punishment, thinking preventive and retributive effects comes from an old tradition that can be called penal modern rationality, to use the words of Alvarez-Nakagawa. The same rationality focused in the anthropocentrism that objectifies who are not white men and divorces humans from the ecosystems is the one that legitimizes the idea that a superior institution, a state or an international organization in this case, must be responsible to apply penalties. In this sense, we just don't need to deal with the complex conflicts that permeate our societies. We don't have to imagine alternatives. This is an epistemological problem because if we try to be open to other rationalities to deal with conflicts, we can also expand the meaning of justice we are dealing with. From this epistemological topic that deals also with epistemicide, I come to the concept of ecocide. The definition proposed tells us about isolated, exceptional, though massive and terrible environmental harms. But the studies about the risks of a global mass extinction because of global warming, for example, don't tell us about exceptional and isolated acts and omissions. The causes are everywhere, and we can't understand it without being aware that there is a structure of financial capitalism that stimulates the devouring of nature. If we go to the causes of deforestation in Amazonia, for example, we deal with losses that are promoted day by day, with the invasion of public lands, the participation of transnational corporations and financial institutions in mining activities in indigenous territories, the expansion of the agribusiness border. So ecocide in Amazon is crucially related to all kinds of violence that started by the colonial violence, and it's reproduced in terrible ways nowadays. None of those activities could be considered ecocide in the definition. There is more. The economy is based on pollution, waste, fossil fuels, meat consumed. So it's not being challenged. And it's not one person or two who are actively contributing with this. So I know that those questions I raised are not new, but I'm really concerned about the energy we're putting in the ICC and punishment. In a way, we already know it's not effective to prevent harms, that probably will reproduce racial and colonial rationalities to deal with environmental harm, while avoiding debating other possibilities, for example, alternative models for the economy. And there is no way without facing the actual causes of ecocide. And we must challenge the economy and think about also other rationalities to deal with our relationship between human beings and nature, if we can do this divide again. So my considerations are these ones, and thank you to everyone.
Thank you, Marília, for getting us off to a great start with a very, very broad range of issues there that I think we'll come back to. We have to come back to in the discussion. Some pretty profound issues being raised there. So, Tameka, are you ready to present next? That would be great.
Yes, I'm ready. Thank you very much for the invitation. I'm thrilled to be here, everyone. I'll share my screen here. Are you able to see my screen, everyone? Thank you. Okay, so I will start by saying a little bit about my background. I entered academia after spending over 10 years working in regulatory investigations in Jamaica. And by that, I mean, I was involved in competition law regulation, investigations of financial crimes as well, such as money laundering, Ponzi schemes, and the like. What I came out of that experience with was this profound knowledge that there was a disconnect between the laws and those that the laws were supposed to protect. So it was a thankless job in that the public never seemed to appreciate what we were doing, and it never really seemed as though the laws that were in place by the regulatory bodies that I worked at were successful in, accomplishing their goals. This led me into green crime, which was something I naturally evolved into researching while I was in grad school, because it was such an issue that was happening in Jamaica at the time. And so I decided that for this presentation, I'd like to share my view on ecocide from the perspective of a small island state in the global south. So the topic is, the title of my presentation is Green Crime in the Blue Mountains, Eco-Colonialism in Jamaica. And while I agree that there are significant benefits to making ecocide an international crime, I'd like to highlight some of the challenges that may be faced if the International Criminal Court should attempt to prosecute offenders operating in small post-colonial states such as Jamaica. Now, in a post-colonial states, there are many of the conservation policies and laws that are currently on the books emerged during the colonial era, with colonizers enforcing their concept of environmental protection and which lands were best suited for protection and development. To further compound this problem was the fact that countries such as Jamaica were subject to structural adjustment policies, which specified the implementation of regulatory bodies and regulatory laws without ensuring that there was capacity or local buy-in to these institutions and policies. Now, there are additional ecological complexities based on the fact that Jamaica, as are many other post-colonial states, Jamaica is a legally pluralist state, which means that former indentured servants, those that were enslaved, that were brought to that island, all brought with them their own laws, norms, values, and beliefs, many of which are alive and valid today. So many of the reasons that we have had a failure, if we could use that term, of environmental governance is that we have not taken sufficient account of those social and ecological complexities in implementing environmental laws. And this, of course, can be problematic with the implementation of yet more laws, if only from an international perspective. The research site that I'll be using to advance some points for consideration is the Blue Mountains of Jamaica. It's a UNESCO World Heritage Site, so designated in 2015 for both ecological and cultural diversity. Ecological because of its endemic plants and animals, and cultural because it's the home of Jamaica's Maroons. Now, Maroons are the descendants of the enslaved, which escaped slavery to the Blue Mountains during the 18th century, and they joined the indigenous Taínos Indians in those mountains. They therefore are indigenous. Now, after much warfare with the British, the Maroons signed a treaty with the British in 1739 for their freedom, and they were allotted land as well. As a term of that peace treaty, they also secured legal autonomy, which means all legal matters are adjudicated by the Maroons. They vote for their colonel and they maintain their own autonomy without the oversight of the state. Based on the importance of this site, as can be expected, there are numerous legal provisions which are governing the environment in the Blue Mountains. As you can see, however, many of these laws were on the books before Jamaica's independence in 1962. What has essentially occurred, especially with those structural adjustment policies that the country was forced to sign to from the IMF and the World Bank, is that laws continue to be grafted on in fulfillment of those structural adjustment policies, and that continues today. Now, what you're seeing in this image are rates of deforestation in the Blue Mountains. It's surprising that even with the abundance of statutes, there is continuous and consistent environmental degradation in this region, demonstrating that laws in and of themselves are insufficient for protection, environmental protection, particularly in poor states. The corporation that is largely responsible for this environmental harm, this deforestation, is the Japanese company UCC Ueshima, which began its coffee operations in the Blue Mountains in 1981. Now, the UCC Ueshima Coffee Factory now owns and produces 80% of Jamaica's Blue Mountain coffee. They obtained Rainforest Alliance certification, and they claim to follow the recommendations of the United Nations and the International Labour Organization in terms of minimum wages, maximum work weeks, and the right to organize. However, it must be noted that this is different from fair trade, which truly protects farmers and workers. And Ueshima largely operates with impunity from the state, which begs the question, when market conditions drive land use, resulting in state-facilitated environmental harm, how and in what forms could the International Criminal Court help? Now, some of the impacts that we have found happening as a result of the environmental harm in the Blue Mountains is that the runoff from coffee factories is impacting the Maroons, especially in terms of their rivers, which they depend on heavily for their livelihood. There has been very little help from the state in this regard. When the Maroons have sought state assistance, what they were told to do is that because there is little evidence as to who is responsible for the pollution, they should find a way to catch some of the pollutant while it is being sent into the water. They should travel to the capital of Jamaica, which is Kingston, have that water tested all at their own cost and at extreme expense. And then only when they have that chemical evidence is the state likely to step in. The state is aware that this is very unlikely to occur, and it is essentially their way of saying, you're on your own. We're not willing to step in here in the face of this corporate offender. Also impacted significantly by this are the small coffee farmers that remain in the Blue Mountains. They are largely being pushed off their land. Those that have decided not to sell their land to Ueshima are suffering greatly for that. At the lower end of the slide here, you'll see me holding an empty box. It holds 60 pounds of coffee beans when it is full. For each 60-pound box, small coffee farmers can earn approximately 50 cents per pound US. Whereas the coffee beans exported to Japan, the same coffee beans from the Blue Mountains, typically fetch a hefty price of $45 US per pound. So for coffee farming to be profitable, the small farmers have had to acquire additional land for farming by moving more inland past the buffer zone that I illustrated earlier and into the protected area of the Blue Mountains. That is resulting in the criminalization of not Ueshima, but the small coffee farmers that are trying to produce additional coffee. Interestingly, if you go on the Ueshima website, you'll see a notice that says we dispatch Japanese coffee experts to neighboring farms in Jamaica in order to improve the technical expertise of the area and further stimulate the Jamaican economy. That's their diplomatic way of saying we dispatch people to small farms to try to get them to sell those farms to us. While conducting my research in this area, I also spoke with the park rangers who are most intimately involved with the monitoring and oversight in that region. Now they are overworked, underpaid, and they lack support. There are 15 rangers per 200,000 acres in the Blue Mountains, down from 25 park rangers from the year before. Monitoring is largely ineffective because of the small number of park rangers. Monitoring takes place on specific days at specific times. So small green offenders tend to know the days on which the park rangers will be on patrol and simply avoid any kind of environmentally harmful activity on those days. There's also a lack of judicial support. So park rangers indicated that when issues are brought before the court, those dockets never get to court. So they are demoralized. And also there is the issue, the inherent issue of environmental offenses being difficult to prove. So overall, the question that I'm left with is, how would the International Criminal Court prosecute cases of environmental harm? How would they go about this in countries that have weak institutional capacity, such as Jamaica, very little collaboration and regulatory oversight? The flagship Environmental Protection Agency of Jamaica is NEPA. NEPA has largely stepped back from its responsibilities. Would the International Criminal Court be depending on NEPA to provide it with the evidence to support any allegations of environmental harm? And what of the overburdened rangers? Where would they fall in this process? So to me, some of the implications and additional questions are, is it also likely that the sovereignty of poor island states would be eroded, which is a further extension of colonialism? What would representation of these states look like in the International Criminal Court, and who would determine this? And has assistance from the global north worked in the past? And I'm speaking here with reference to the structural adjustment programs and now this feeling of distrust between the global south and the global north, in the event that someone should suggest maybe it's just assistance that those poor small island states need. So thank you very much for your time. Thank you.
Thank you, Tameka. That was great. That was a really fascinating case study. And of course, you've spoiled Jamaican Blue Mountain coffee for all of us now, because we now know how it's produced and the conditions, and we could have guessed, but you know, I think you gave us a very detailed case study and a really strong understanding of some of the limitations that we will face with the ICC. So thank you for a fascinating talk. So next we've got Alexis. Are you ready to go, Alexis?
Yeah, I am. Thank you, David. Hi, everyone. So I will first address some theoretical issues, turning to more practical and strategic considerations afterwards. But I made the distinction heuristic, and I don't want to stress any strong separation between theory and practice, as you will see later. So let me start with some theoretical considerations about environmental politics in general. I think the main challenge we have today is the progressive composition of a new collective for humans and non-humans. And in this, I'm with Philippe Descola, Bruno Latour, Isabel Stengers, and many others, I would say. We need to find new ontological ground, a new constitution different from the modern colonial constitution. We need a new cosmopolitics. Because the challenge we have ahead is not just about our relationship with existing non-humans, but with non-humans to come in different shapes, in the forms of AI, in the forms of viruses, as our current experience shows with the pandemic, and in forms we don't know at this point in time. So it is not enough to make some political or legal reforms here and there to introduce a few rights or to criminalize environmental damage. As will become clear later in my position, I'm not saying we should not do this, I'm just saying this is not enough. Instead, I believe we need a new ontoepistemology, a new epistemic and ontological framework, or ontoepistemology, as Karen Barad says, to capture the new circumstances in which we are living. The modern colonial constitution does not do the work anymore, and it is not just that the dualisms that modernity coloniality upholds are problematic. Categories that you know very well, such as nature, society, body, mind, subject, object, and so on. But that these categories don't help us understand the phenomena with which we are dealing today. So let's take climate change as an illustration, as an example of what I am saying. If we aim to grasp climate change in all its complexity, we need different ontoepistemological categories which do not partition our reality in nature and society. Because climate change is not just a natural phenomenon, right? It is a social phenomenon as well. It is man-made, the result of an economic system of production. This is what the much discussed idea of Anthropocene, for example, brings to light so well. We humans act today as a geological force. At this point, we cannot say that any natural disaster is just natural. It is probably as natural as unnatural, artificial, anthropogenic. So the hybridity of the challenges we face indicate that we need a new ontoepistemological lens. Now, some have started to look for such a lens, going beyond what could be called Western abyssal thinking. Some have tried to use other people's ontological words or cosmological frameworks, and in this, Viveiros de Castro's work, for example, has opened a path of inquiry. Others have tried to explore new theoretical and epistemological constructions. I'm speaking here of trends ranging from new materialism to object-oriented ontology, actor network theory, posthumanism, etc. But why is this ontological discussion relevant for environmental politics, and more particularly to rethinking ecocide, which is the topic that brings us today? Let me answer this straightforwardly. I think that only at this level of analysis, at the ontological level of analysis, will we be able to assess if ecocide is a good or bad idea in the context of environmental politics. In principle, an ontological examination shows us that the idea of ecocide is problematic, to say the least. Ecocide is based on a naturalistic ontology which supports the dualism between nature and society. So ecocide will be to nature what genocide is to humans, we are told. The crime of ecocide therefore reinforces artificial separation between nature and humans. Let's note that, by the way, that naturalism is just the other face of humanism, the ethics behind the concept of genocide and human rights more generally. Naturalism, that is the idea that there is nature out there, somewhere different from society, is the basis for humanism. That is the idea that human beings are something apart and exceptional. Ontological naturalism and ethical humanism go hand in hand. And this pair has had an essential role laying the anthropocentric foundations of our collectives and justifying humans' mastery over nature. But ecocide is also problematic, and this is very important because it reifies the modern colonial idea of nature. This is an ahistorical and invariant nature, external materiality, devoid of human traits and agency, a kind of inanimate nature, as Bruno Latour says. The kind of nature that has made the modern colonial capitalist exploitation of the planet possible, actually. So with all this in mind, let's move to some practical considerations. Given these problematic features of ecocide, the question is, should we advocate for ecocide as a possible tool to fight climate change? My answer is, unsurprised, yes, but under certain particular conditions that should downplay, in a way, the problematic aspects of this category. Let me highlight that examination at the ontological level not only shows the limitations of ecocide, what I showed before, but also indicates something else, something that is very important, which is the imperative necessity of creating spaces to revise our basic assumptions and the frames through which we apprehend reality. And ecocide could help that endeavor, I believe. Ecocide has a kind of expressive power, of symbolic power, that could open discussions and foster, in turn, a new perception of nature and on humans, which humans have seen so far prefer as mere resources, as anything but things for exploitation. Changes in legal language could also encourage political debates and the emergence of new sensitivities, changing how nature and non-humans are viewed, nurturing the progressive composition of new collectives, that I mentioned before. In other words, ecocide should not be the end, but just an excuse to open the discussion. Ecocide would be important not because it would allow criminalization, and I would like to highlight this, but because it would remove pre-existing normative barriers, providing a space to bring alternative views and pose questions about the consideration of non-humans. In other words, ecocide could allow us to welcome non-humans into politics and law, that is, it could facilitate and provide a forum, one of many forums, for ontological discussion I referred to earlier. However, for ecocide to work in this way, we need to frame it in a long-term strategy. And in this, I believe Marxists have wonderful ideas about how to advance a transformative agenda, and the distinction some of them make between strategy and tactics is fundamental here. So following Gramsci, we can define strategy as those actions concerned with how we achieve long-term goals, what Gramsci calls organic changes, whereas tactics, in contrast, involve the actions through which we fulfill shorter or immediate aims. Ecocide can be used as a tactic in the short term to remove existing barriers and to change our perceptions, but only if we place it within a long-term transformative strategy. Moreover, ecocide could become a nodal point to align ecological struggles, producing what Ernesto Laclau has called a chain of equivalences between different environmental demands, but only if ecocide is framed strategically. Now, to figure out the forms the strategy should take to be transformative, we need to habilitate the ontological discussion I mentioned earlier. That is, we have to ask what are the organic changes we want to achieve, to what kind of polity do we aspire, what kind of relationship do we envision between humans and non-humans, how does this relationship reshape, for example, property rights, corporate responsibility, and the obligations of states, assuming, of course, that property, corporations, and states endure our ontological examination, right? So if we don't bring ecocide into a long-term strategy, we'll not open but close the discussion, because as our ontological examination show, this category is set on a naturalistic footing. Ecocide must be a catalyst for the ontological discussion, but only to be brought later to a strategy shaped by that discussion. So this is not a paradox, it is just how usually political discussions unfold on the ground, that is dialectically. So let me move towards a conclusion before I run out of time. So it could be said that we are in a way plunged in a war, what Arturo Escobar has called an ontological war. Ontology is our field of struggle because Western naturalism is at the core of environmental degradation. Now, I am aware that for activists and for some academics as well, the ontological exploration I propose here might sound like a waste of time. Indeed, we are dealing with urgent problems. We are urged to act now. We have to do something, right? But the question is to act how? Because this is part of the problem. We are not sure which course of action to take, if our actions will be effective or counterproductive. Without strategy, action is blind. And it is precisely because we don't have time that we must take the time to think carefully about strategy, which, as I hope I have shown, is another word for ontology in this context. It seems to me that arguments pitched at the level of ontology, far from being detached from worldly practice, are vital if that practice is to be exercised in transformative ways. In short, and with this I finish, I believe that an effort of both critique and reconstruction at the level of very basic assumption is not only required, but strategically important for a praxis engaged in the progressive composition of a new common world, which is what we need right now, as I mentioned in the beginning of my presentation. So I will leave it here. Thank you for listening, and I'm looking forward to your questions.
That's great, Alexis. Really important way of positioning a discussion, I think. And I hope we do come back to that if other people don't have questions about the distinction between strategy and tactics here. I think I may ask a question of you on that. So thank you very much for introducing that very important way of thinking ontologically about ecocide. So next we have Jose. If you're ready to go, Jose.
Yeah, thank you, Dave, and thank you everybody for this great conversation, and thank you for having me and to be part of this panel and to be part of this dialogue. To be honest, I have, the way that I'm going to frame my talk is more around questions, a series of questions that I have concerning the crime of ecocide. And I would like to think about three specific aspects. I would like to think about colonialism and international law, something that Marília and Tameka had already pointed out. I would like to think about reparations, and I would like to think about green corruption. So I'll be centering my talk on these three concept ideas, but also framing it as a series of questions. So as already the panelists, Marília, Tameka pointed out, it's important to keep in mind that the development of international law cannot be dissociated from colonialism. But this is not new, right? This is not a new statement. There is plenty of literature on how colonialism, especially Spanish and Portuguese colonialism, defined the codification and formation of international law in the 16th century. So I'm not going to expand on that tradition. However, I would like to underscore the importance of thinking of the mechanism to prevent that the implication, applications, and uses of the crime of ecocide ended up affecting Global South and colonized and post-colonial countries and racialized communities in the Global South, but also in the Global North. So how do we apply, how do we frame the crime of ecocide in a way that it doesn't reproduce the harms and the violence of colonialism, slavery, and other forms of violence and harm produced by modernity and produced by colonialism at large? This is an important question, and it's a question that, in a way, remain unanswered when we think about the crime of ecocide, because it's still centered on the state. It's still state-centered. States are still in charge of ensuring the application and ensuring that we apply this crime. So in this sense, I would like to think about two issues. First, if we center, is the state still at the center of the application of the international crime or the crime of ecocide? We might think that the inequalities and the differences power between lower north state and global south state will be replicated, as we have seen with other crimes such as genocide, crimes against humanity, and so forth. And which is something that already Marília pointed out earlier in this talk, in this panel. So I think there is some continuities in these worries or concerns. Now, I would like also to think about what I have called the transnational network of harm and violence. One of the major issues that we are well aware is that environmental crimes and environmental violence and harm not only take place and oftentimes are not restricted to one state, but oftentimes happen across borders and are in nature transnational. So let's think, for example, coal, or let's think, for example, any kind of fossil fuel, right? So we see that this environmental harm, environmental violence is not taking place only in where the coal or the oil, whatever is extracted, is also taking place across borders. It's also taking place where we produce, refine these products, and so forth. So if we are limiting to the state, we might think, okay, and I'm thinking about a paper that I just co-authored with a good friend of mine, Gustavo Rojas Páez, about the coal industry, right? The coal is extracted in Colombia, then it's used in Puerto Rico to produce energy, and then the ashes were transferred to Dominican Republic. So there we have a transnational network of harm and violence, or environmental harm and violence, that we need to account for. And probably by centering in the state, we might end up looking at the state, but ignoring the corporations that profit out of this transnational network of environmental harm and violence. And that raises the second problematic notion of this colonialism and international law, that is, if we are going to apply this crime, are we going to penalize? Are we going to punish the state? And are we going to only punish the corporation in charge of extracting this or mining this fossil fuel, for example? And while this is important, we might end up harming the state, normally global south states, global south communities and countries that depend on extractivist industry to fund their welfare, or to fund programs that contribute to mobilizing people from poverty. So there is a lot. I don't have answers. I have a lot of questions about how we are more strategically using Alexis framework, right? How we think about this strategically. So, and this kind of tension between punishing and the consequence of those punishment kind of take me to the second big question or concept, and it's the concept of reparations. And I think this is the most important concept or aspect that we have to discuss. And in a way, Marília already pointed out, right? The way that we're framing ecocide is prospective, and we are thinking that prevention, but obviously criminal law cannot deal with prevention in many instances. But how about the historical balance and the harm of colonialism, and how do we deal with the historic balance of colonialism and the environmental degradation that colonialism propitiated and still propitiating today? And so there is an emerging scholarship on the issue of reparation and climate reparation, an emerging scholarship that I think we must consider and try to see how establishing the mechanisms for addressing these harms produced by colonialism can be addressed. And so authors such Keystone Perry have made clear that reparations, environmental climate reparations as reparation for slavery and colonialism must be addressed at the international level, must be addressed at the transnational level. And this is something that, again, if we are centering our analysis of ecocide and the crime of ecocide on the state, might limit our understanding. I have a minute. So to sum up, the last concept that I would like to think about is green corruption. And obviously here I'm trying to push the envelope a little bit, but I would like to think about how these regulations, these policies, the creation of environmental crime, or ecocide might create a new opportunity for the corruption of powerful. And especially I'm thinking when it comes to intangible and financialized economy, and I'm thinking about offshore financial centers and tax havens, right? And this again raises a double or a conundrum. Many of the tax haven, many of the offshore financial centers are in global South, Caribbean, small island countries that are facing, enduring the consequence of climate change, and can be, in a way, used to prevent any fines, can be used to prevent any kind of economic or monetary fines that are imposed to either corporations for engaging in ecocide or engaging in other form of environmental harm. So we must look at these countries and see the double conundrum there, or the conundrum between the colonialism and international law and green corruption. Finally, I think with this, I would like to close. I think I'm echoing here Marília's and Tameka's point of, well, I wonder if we can start thinking about ecocide law and whether or not the effectiveness of ecocide law might be better placed if we stop thinking about punishment and start thinking about justice. And that connects us with the concept of reparation and how we frame ecocide more, not like a punishment, but more as a way of, like act of justice towards those countries and people that have faced the consequence of development and ecocide and climate change. Thank you.
Thank you, Jose, and thank you particularly for introducing some new conceptual and very important, I mean, not just new conceptual perspectives. Obviously, your discussion of corruption, I think, brings a new dimension to it, but the discussion of reparations also gets to the heart of this discussion of justice, as you say, and raises something we have established in other kind of spheres, transatlantic slavery reparations, but clearly that brings a new dimension into any kind of legal responses to ecocide. So thank you very much for that. Okay, so finally we are going to Hannah, if Hannah is ready to take the floor.
Yeah, I'm just gonna share my screen. And then we can begin. Do you guys see my screen?
Yeah.
And do you just see my screen? Or
We
do you?
see you and the screen.
That's
So
good
it's
enough.
perfect. Yeah.
Good. So this is going to be the world's fastest overview of my research. So I will really attempt to make this 10 minutes because there's a lot I would like to cover. I wanted to begin by giving a brief overview of my PhD work, which is called The Outlawed Earth. It's the work that David referenced in the beginning, which is about the ecocidal violence of forced eradication in the case of the coca plant in Colombia, and the use of the herbicide glyphosate in the aerial fumigation of the plant. My methods that I use, I come from the Center for Research Architecture, which also developed the project of forensic architecture. It's a practice-based research methodology, which was basically designed around the idea that environmental violence unfolds over multiple scales and temporalities. Thereby, a multi-scalar, multi-perspectival, and multi-temporal approach is needed when analyzing these forms of violence. So my work basically encompassed archival analysis. I looked at the visual history of the use of photography in the use of herbicides in war, dating back to colonial times into the Cold War, and then of course transitioning into the war on drugs. I did an extensive field work in Colombia, which involved many different methods of spatial investigation through photography, film, situated testimony, remote sensing, and participatory cartography. This is aerial balloon mapping that you see here, which I can talk a little bit about later. So all of these methods were really a response to this issue of how do you look at this multi-scalar, multi-temporal unfolding violence over the earth, and how do you do it in a visual sense, right? That's what my work is about. So all of these techniques kind of came together for me in the construction of what I call the archive of the outlawed earth. And this is really an archive which is about the story of the space that you see on the screen here, which is a small scale campesino farm in Colombia. This is actually an example of what is known as forest farms. They're like, it's a technique of planting which uses the forest logic of biodiversity as also a method of planting. And it's this space that I examine in my research as the space that is also the register of these different forms of entangled violence, which often come together and produce ecocide. So this space is kind of held in stark contrast, and it's not just a space. I need to say that it's also the method and forms of life that the space holds, namely that of campesino life in this case. That's small peasant farmer in English. And that is held in distinction to the space of large-scale monoculture. This is a soya farm in Brazil, actually. So I kind of hold these two spaces up together, and I look at different ways that there are, visual analysis can be done around them to investigate not only what we would think of as ecocidal or environmental violence, but also political violence. And actually how those two things and the distinction between them is a bit problematic, right? For all the reasons that I think the speakers have already addressed. So running very quickly again, I organize my research into these different scales. I begin at the scale of the leaf. In this frame, basically, this is the frame in which I go over the history of aerial fumigation and its imaginary in relationship to this form, which is the leaf, how it was kind of conceived as this obstruction to sight, which also was related to communist insurgency, and how they really became the target of violence during the campaigns of the Cold War. That then kind of transitions into the case of Colombia, where the leaf itself is formally criminalized, the leaf of coca, that is, and it's sanctioned, legally sanctioned to be eradicated also in the international setting. So again, in this form, I go over this history, but I also, in the actual practice, I look at the different leaves and plants that are found in traditional campesino plots in Colombia, and I look at the ways in which the herbicide visually manifests and also, destroys each crop. This is a plantain leaf. I then scale up and go to what is called the field, but this is really what you can call the space of the farm itself. This, of course, involves another kind of looking, another kind of narration, and this is where the technique of situated testimony comes in, which I'll explain more later. This is where forms of photogrammetry and looking at the spatial entirety of the farm comes into place. I can talk more about that later. This is all a sprayed farm that I documented in 2014. This is also where I used participatory mapping techniques. This is, an effort basically to scale up and to look at these spaces in transformation. This is actually a reclaimed field from sugarcane monoculture, which is actually being converted back. This is a whole nother story, which I don't have time to tell you, but it's an indigenous movement called the Liberation of Mother Earth. They reclaim sugarcane in this one area of Colombia called Cauca and convert it back to traditional indigenous agriculture. So this was the beginning of that transformation that I caught here. I then look at this field, this space through aerial and remote sensing, which I do not have time to get into, but certainly if there are questions, I can answer those later. So really, thinking about how these forms of violence manifest visually kind of introduces the question of evidence and how they might, come together to form evidence of environmental violence or ecocide, right? And this kind of brought me into a moment in my research where also there was a lot going on in Colombia. There was the peace agreement, first it was the peace accord, like the negotiations. Sorry, 1 second. I'm not in my home, so this is a bit on the cuff. So there was a peace negotiation going on with one of the major guerrilla groups there, the FARC, which culminated into a peace agreement. And then from that peace agreement, there was a discussion about what transitional justice and the post-peace accord environment would look like. And that actually included what the role of the environment was, and also how environmental crime would be handled in these transitional justice forums. So I was very lucky to be able to witness and participate in those debates at that time, but that also led to the actual creation of these transitional justice forums, one of which was a truth commission who approached forensic architecture in 2019, I think, maybe 18, end of 2018. And we began a 3-year collaboration, which just culminated in a major exhibition in Bogota. And you'll also see it in the final report of the Truth Commission, which is being launched next week. This is where I was actually really able to test some of the concepts and methodologies I had developed during my PhD work. One of which was the method of situated testimony in relationship to environmental crime. The Truth Commission actually asked us to take on a very massive violent dynamic that happened during the armed conflict, which was land dispossession specifically of campesinos in one region of the country, which is called Urabá. It's a region that is used for large-scale banana industry, and the banana industry, which has come together also with a lot of paramilitary and military violence, has led to a mass phenomena of land dispossession of campesino communities. So when we were approached to do a case about land dispossession, I thought that the idea that I had started to look at in my own work, that the space of the campesino farm could be the spatial register of these various forms of violence, which basically encompass land dispossession, could be applied. So we developed further the FA methodology of situated testimony. Situated testimony has a longer history beyond forensic architecture, but again, not enough time. Situated testimony in relationship to forensic architecture is where a witness sits down with a 3D modeler and basically has the ability to reconstruct their memories, also memories of violence, right, into these 3D spaces. In our case, it was not using the model as like what was traditionally used in FA, which was to like look at, let's say, more traditional built environments, like urban environments, and rather look at the space of agriculture, look at mass environmental transformation over all these different scales, and have the witness, in this case, the witness being the campesino, apply their not only their memories, but also their forms of expertise, because it's really the forms of expertise of knowing and working with the earth that can actually have the capability of also narrating this thing called earth memory, right? So this kind of came together, their forms of expertise along with the forms of expertise of those of us working in London with modeling, came together into the space of Unreal, which is a 3D, well, it's a gaming software actually, which you can also use to recreate whole worlds, which is now kind of what we're using. This is a zoom out of the man who you saw in the previous frames farm. And I'm probably at the end of my time. Yes, no? A little, I can't see.
Yeah, sorry, I have sent a message, but just if you just wind up, that would be great, Hannah. Yeah.
No, I just wanted to show everyone the how this looks. This is all available in Forensic Architecture's website, which if you go to land dispossession, you will actually be able to to see it. Yes. Now I cannot find this. Oh yeah, oh, here it is. Share that screen. So play. So yeah, this is the
dos piezas.
This is an example of actually how fieldwork situated testimony comes together into this space, which is also used doing aerial analysis, remote sensing. So basically in this platform, you have the potential of combining these different scalar analysis to have them also work together to tell this very complex history of environmental and political violence, often which culminates, yes, in forms of ecocide in this particular region of the country. So, yeah, I encourage you all to watch the films. And yeah, thank you so much.
Thank you. I think it's still, is it still running? Thank you, Hannah. That was really fascinating. And also, you did something that none of the other speakers did, which was bring political violence into the discussion of ecocide and ecocide into the discussion of political violence in a very, very focused way. And also discussing ecocide and environmental destruction as, and restitution as part of a peace process, which I think is really obviously fundamental to your work, but also a new dimension to what we've heard. Listen, I just want to say to all the speakers, I always feel really bad. We feel it's a good format to give everyone 10 minutes, right? And you've not seen it, but I've been intimidating people with like 1 minute messages, but I didn't really need to because everyone kept to their time. And I really think that the scope of discussion and the richness of discussion we've had from all of the speakers, I'm not just saying that, but from all of the speakers has been incredible. So I just wanted to register that thanks before we move into the discussion and questions. So please, either questions in the chat, and Angela and I will try and monitor, or if you would like to put up your hand, either, well, I won't see you if you actually put up your hand, but I mean put up your hand using the function. Please feel free to do so if you want to ask a question. We've got, I guess, we've got a bit of time for questions and to deepen the discussion if anybody wants to. Don't make me ask a question because they will, honestly, the speakers won't like that. I've only got daft questions and difficult questions to ask. But if you insist, okay, maybe we start on the question that Hannah raises, and maybe I pose that to the whole panel, because there obviously is an intimate connection between political violence and conflict generally and ecocide in different ways that I think were touched on, whether that's the kind of the legacy of fairly extreme violence in Jamaica that shapes the experience of the Maroons and the present day, whether that's the financial violence that we find embedded in tax havens, which fuel and fund, as Jose pointed out, ecocidal activities, or whether that is the ongoing political state of things and the fundamental problems we have at the level of regulation and international law that Marília raised, and maybe if we think a bit more kind of deeply in an ontological sense, you know, the fundamental kind of political problems that a concept of ecocide creates for making it unable to break the colonial distinction between the natural world and the human world that Alexis raises. They're deeply political questions, and I think all of the speakers in some way did talk about the state and centered the state in their analysis, whether they were talking about regulatory processes, whether they were talking about colonialism. So I suppose that's a question just to respond to. Do we have to have a distinction here between private actors and the state, between the political dimension and profiteering, which is kind of, you know, or is that, can we see ecocide as a concept which can wrestle with that distinction. I'm sorry, Chile sin ecocidio, I've just asked that question. So we'll go to you next. But maybe I could get the speakers to respond to that. I'm seeing Jose nodding. Do you want to go first, Jose?
Yeah, sure. I mean, it's a really important question and concern. Like, how do we think about political violence at first, right? And the different and multiple manifestations of political violence, from colonialism, slavery, to nowadays right-wing, extreme right-wing violence, right? And how that is entangled with concrete forms of environmental violence and other form of dispossession and the legacy of racism and colonialism. And obviously I'm thinking from this context, I'm in Illinois, US, so environmental racism and right-wing violence is intertwined, right? I think that is important, and therefore the concept of reparations might be a really important element to that. Also, I would like to go back to the concept of tax havens, and I would like to go back to this tension between the private actors and the public actors or the state, and how the tax haven blurs that line, right? I know you have written about this blurry line between the state and the private, right? And how the private is created by the state, right? And how the private or private corporation are externalization machines, or that externalize the outcome, especially the negative outcome or outputs of businesses. So tax haven kind of operate in that same way. They're not only taking on the negative outcome of ecocide, but they are also enabling it by, allowing these businesses to establish themselves, or these banks to establish themselves, and kind of deviate on responsibility, which is something that I think we should kind of go over. Responsibility, and we are not discussing that enough.
Yeah. Okay.
So yeah, I think there is a lot.
Thank you. So state responsibility at the center. Anyone else want to respond to the question of enduring forms of political violence and the role of the state in ecocide? That'll be a no then. I'm going to go to Nanda, and you've got a question.
Yeah, I just wonder, I mean, I didn't hear in any of the presenters the mentioning the right of nature, that I think is mainly the center of the indigenous people as a sort of like as we in South America, I think some of us, we are from the region. We try to center the conversation towards giving the chance to them to tell us how to do in the context of ecocide, of course, no? I think it's super important. And my question is, how do we put together, for example, Jose was mentioning about the reparation, that is something very vital, but I think it's also very complex in our territories, how within it has been mentioned also corruption, also colonialism, but I think it's something that it's sort of like we have inherited. As a sort of the colonialism behavior, we have inherited from the colonialism itself, as a sort of like as a maybe ecocide and the ICC, it might sound as a sort of like and also a pattern of colonialism. I think it's the only way, as we see, even though it's no immediate action, it's a way of actually to represent the right of nature in one way or another, even though the companies or the multinationals get penalized by it. But my question is, how do we integrate in this conversation the right of nature from then on to maybe take action in all the points that you all have mentioned? For me, it's very important. I think that we have forgotten that we still have to solve certain issues, as I think Marília have addressed in the beginning, is that it's all about the legal factor and everything, but we also need to put attention in how we and different territories can apply the ecocide independently of the ICC. I think we have the chance to transform the definition, the international definition of ecocide to our own territory. I think we are transforming right now in the South, in South America especially, we are transforming right now. Some of us have recognized the right of nature and we can take it from there. And I don't know, I just wonder how we take the discussion around the rights of nature and how to bring it on the table again.
So I think there's, can I just say, I think there's two big questions in your contribution, and the first one, obviously the second one is the point about the rights of nature and whether that can feature in the debate. But I think the first point you made about how perhaps a law of ecocide can be more important at a national and local level, or as important, if not more important, than an international level. Maybe I'll ask the panel to respond to that question first. And Marília, you were named, so I'm looking at you if you would like to respond. I don't know.
Okay, thank you, David, and thank you for the question, for the participation. I can speak about Brazil, for example. We have now a bill that's in the Congress, and I think we have the main problem I'm addressing in my speech is about why to put our efforts in the criminal law. Because when we talk about the rights of nature, and I really find this really important, and I agree with you, we are not necessarily talking about criminal law. We are not talking about recognition. We are talking about the need of understanding the importance that nature has for itself, independently of our interests. And there is another important thing that you also addressed, and I super agree, that's about what is nature. When we talk about nature in the sense of this divide between human and nature, that's this binomial we have already talked about before, we are not dealing with an epistemology that's ecocentric, and we should do that. And I think to overcome our problem with the ecocide and nature destruction, we have to go beyond this anthropocentric point of view, even to describe what is nature. What are we wanting to protect? And other kind of knowledges are needed to think about it. But thinking about the rights of nature inside this more ecocentric concept of nature doesn't mean to talk about criminal law, because the problem with criminal law, and I am seeing the case of Brazil, that's what I wanted to talk about, is that first, they are creating a very specific and exceptional act or omission that could cause the criminal prosecution. And this is not about what we are seeing every day, the day-by-day destruction of Amazon, for example, and all the problem with the pesticides and the chemical industry. This is not about what they are wanting to create as a another criminal type. And what's the problem with this? Because I am not against, it's not, I don't think it's about to be against or in favor of criminalization, but it's to focus our energy in something that we really know that has can have another effect. That's, it's something like you can just blur all the conflicts you have behind the problem of ecocide. when you say, well, now we have a law, and that's what happened here when we created the environmental crimes law in Brazil in 1995. It was like, wow, all the environmentalists were really happy with this. But we can say that we evolve anything about nature protection since then? We know that we didn't, but we have now a government who can say, for example, Bolsonaro will sanction the law of ecocide in Brazil. You can imagine how greenwashing this is for somebody who supports the killings in Amazonia, who supports the deforestation and everything. So I think that the symbolic effects that everybody's telling about, these symbolic effects can be appropriated by these ecociders. And that's what we are seeing also with the companies when we talk about this green capitalism and everything. So I think to talk about rights of nature is not about, shouldn't be about criminalizing things, because we are not dealing with the problem that's behind ecocide. That's my perspective.
Thanks, Marília. I know that you've raised another question there, which is another big question that I think we should come back to, which is how ecocide may be appropriated by the least expected people, or the people we least expect to. But I want to focus on the question I wanted to give. I know that Alexis will want to come in. I assume he wants to come in on the question of the rights of nature. But I also wondered if Tameka wanted to come in on either of those questions.
Yes, absolutely. Thank you. When speaking about the rights of nature, this took me back to my time with the indigenous Maroons in Jamaica, which were the best representation that I could think of a community that understood the rights of nature. They valued nature to the extent that they not only relied on it for their livelihood, but felt that it was sacred, which goes beyond what the International Criminal Court is likely to view nature as. I don't believe that additional laws that are enforced by the International Criminal Court will be valid unless the voices of the indigenous are centered, unless the voices of those that are often criminalized for committing environmental harm, until those voices are heard. And I say that because those that are looked at for prosecution in Jamaica, for example, are those that are not those are not the most egregious offenders. I take, for example, the Rastafarian community. They also reside in the Blue Mountains. They are also protected by religious law. They too have a strong reverence for and respect for nature. The state is going after the Rastafarian community because they say that they are encroaching. They're living on land that does not belong to them. The Maroons, who are not involved in coffee production, but happen to live in a community that would be perfect for coffee farming, are now being, the government is going after them through taxes as a form of punishing them. So you find, and they are saying that because they're not paying the taxes, they are offenders. And so the state is getting involved and is prosecuting or trying to prosecute those who are not the ones who are most offensive or who are conducting environmentally harmful activity. My concern is that if that's what the state is doing at this level, then it is also something that can be done at the international level by the ICC, that you will find, as in cases of criminal law, street crimes, that those who are being prosecuted or who are being, the action is being enforced, those laws are being enforced on most, are not those that are actually committing the most egregious harms. That corporate offenders, as in the case of white collar crime, will find enough lawyers, will find enough resources and capital to evade law. And that's my primary concern. So all of this to say, Nanda, that yes, the rights of nature is important. The voices of those that view that as important are not being heard right now. And until that is what happens, I do not foresee that enforcement and prosecutorial work by the ICC is going to be particularly effective.
Thanks, Tameka. Is there any of this you wanted to come in on, Hannah?
Yeah, I mean,
No.
I was thinking about, you know, the rights of nature as they exist right now in Colombia. Colombia also has some great environmental laws, some nature that has been granted some rights. But yeah, as everyone is saying right now, the actual effects of this on the ground are really yet to be seen. And in fact, another issue that I look at is green militarization in my work, especially in the space of the Amazon, which is basically, I mean, looking at the same dynamics that were just also explained in Jamaica, Brazil, you know, where the smallest scale producers are basically criminalized, actively attacked, and also arrested and prosecuted for environmental destruction. And in fact, they are the lowest on the chain, the economic, well, not just economic chain that produces this form of destruction. So I just don't foresee, yeah, again, like, I think the rights of nature debate has gone through a lot of different transformations. Like, I think at first people were very enamored with the debate on a kind of legal global level, and you know, like, oh, there's these rights of nature being granted in these places like Latin America and New Zealand, but actually, I think it's often used as a cloak and a mask for you know, corporate structures to hide behind, and I think that's very evident now. So, you know, in relationship to transitional justice and these, you know, active forums that we're seeing now in Colombia, like, you know, again, it's not the case where, you know, you're looking at like basically inventing new ways of analysis, especially when, you know, transitional law is anyway, it's different than other forms of law and you know, criminal courts and things like that. So I think that it's still being worked out, but I really do think that there is a potential, especially if indigenous voices are included, if small farmers are included, if these communities actually value and understand how environmental reparation works, that you would actually have a potential of considering what rights of nature can be.
Thank you, Hannah. Thanks very much. Alexis, do you want to say something on this question? Yeah.
Yeah. So I would say that I agree with you, Nanda, but I also disagree in relation to the use of the rights of nature, because, you know, I agree that there should be or there is some kind of relationship between the rights of nature and the idea of ecocide, and actually both ideas could reinforce together, because when you speak about, for example, violating the rights of nature, there should be consequences to those violations, and one consequence could be criminalization, right? And ecocide is a form of criminalization. So there is a connection between both the idea of rights of nature and the idea of ecocide. But the same problems that I see for ecocide, I see for the rights of nature, because the rights of nature are also based on a Western ontological footing. You know, you have naturalism at the base of the rights of nature, the idea that nature is something over there, something inert and kind of inanimate nature that we should protect. And that idea of nature is problematic, because it's the same idea that is at the base of the exploitation of nature that drives capitalism, for example. But on the other hand, I think, as I said before, ecocide, I think that we can use the rights of nature to open up the discussion, to say, okay, we have to look at this from a different perspective. We are going to be still within some sort of naturalist framework, but given the discussion within that framework could open and could help to bring other perspectives. And therefore, I think that we can do the same instrumental use with the rights of nature that I'm proposing here for ecocide. We have to use these categories to open the discussion and then to move forward. You know, we can use it in the short term to open certain discussions and then move forward to question, you know, the ontological basis in which these categories are based and that the foundations of the problems that we have now. And in relation, I'm not a critical criminologist, so I also have some some sort of issues with using criminal law or the criminal justice system to promote, let's say, social change or political change. I know all the problems that this has, but coming from the background from where I come from Argentina, I think that we can use in a way instrumentally the criminal justice system if we frame these actions within a strategy. That's why I mentioned the issue of the strategy. An example for me is the case of the mothers of Plaza de Mayo, right? All the work that they did using the criminal justice system, not just to criminalize people, not just to put the dictators in jail, but to open discussions, to open discussions about the responsibility of economic actors, to open the discussions about gender violence within the concentration camps, to open discussions about beneficiaries and so on. So in my experience, the criminal justice system could be used to open discussions, more general discussions, and to put people and corporations and structures on the spotlight. That's why I'm saying that, even knowing the problems and that we have, of course, all alternatives as well, because we can use our energies, as Marília said, towards all political ends to try to create or to bring social change using other means. I don't know why we should put the discussion between this or that. Why we can use all the tools that we have. We have people that would like to use their energies to use the criminal justice system, and other people that would like to fight for legal reform or to struggle for revolution. But we have to use all the tools available. I think it's not necessary to reduce our alternatives to just to changing to create big systematic changes from the very beginning, because small changes could bring also big changes at the end.
Thanks, Alexis. Thanks for your perspective and for making the case for law as a site of struggle. I'm going to move on from this question, although we're not going to, we're not nowhere near resolving the series of questions that were asked previously, but I'm going to move on to Tamara, who has a different question, I guess. Tamara.
Hello. My English is a little poor. I'm from Mexico. And I want to say a few questions and also ideas. For example, in Mexico, we have a big issue with the narco, you know about it. And now the cartels of drugs, some of them are doing a business with water, and they are behind the ecocide. But the big thing is that the organized crime and the state and the corporations have this complex relation of shared interest and complicity. So the thing is, there is no way to think about justice in this kind of scenario. And we have, for example, 58 defenders of land killed the last 3 years. And there is no justice in this kind of cases. So there is a big issue with justice and punishment, because I like the idea of Jose Atiles of justice instead of punishment. But if we think about corporations, organized crime, and state that kill people and also makes ecocide, we need to think about what do we do with these people. For example, the families of the victims of murder wants to see these kind of people in jail. So also the thing is, how do we protect nature and we make justice and we do something to stop ecocide? it's a big question. I think the thing is the state has stopped or closed the possibilities of using law if the state is making also the illegal act permanently. So I think it's a big problem. For another thing that I think you know is in Mexico we have more than 1,000 disappeared people in the last 10 years, and it's still happening. So we know that the people that defend land are indigenous mostly. We know that the defenders of land are going to be killed or disappeared by these three forces, because some people make their own investigations of these cases, and we find almost every time that these three actors are behind the murder or the disappearance. So my question is, what can we do in this kind of realities? I am a lawyer, and I don't believe in law in Mexico. So what is possible to do in this reality? Thank you.
I mean, almost, Tamara, we should be asking you the question that you just asked, because you're a lawyer who fully understands the limits of the law. You've just explained it beautifully and succinctly and accurately what the limits of the law in the most extreme circumstances are. And I think I think you've raised the most fundamental question. But I suspect if we put it back to the panel, they're going to say the same things they've said in the last 20 minutes, But what do you think? I mean, can I ask, sorry, is it maybe a bit rude of me to ask the question of you, because I think you have an experience and a position that's really interesting. So, I mean, do you think that the ecocide law at an international level would shift or make any difference to what's going on in Mexico?
I think, for example, I work in a human rights group, and in other cases of torture, sexual torture, things like this, is most often to see cases where the justice is made by people, we say from down, not from up, because we know that if we go up, we're going to find everything So the thing is, we may have investigations made by the organizations, by the people that are victims. Now in Mexico, there are so many experiences of justice, not state justice. We have the thing of the Zapatistas communities that have their own forms of governance, and they have their own forms of justice, but it's a territorial thing that doesn't apply to all the country, for example. So when we are talking about big corporations, for example, in the town I live, Puebla, there is a big issue with Danone that is taking the water of people, and it's a huge thing, and we don't know what to do to make them stop, and the state won't do it. The state is supporting the multinational, and we are starting to think about international ways. But I also think about what you say about the ICC, for example. I think maybe if we could do something between people around the world, not states, something big, something with force that is not institutional or official, maybe we could do something. But I don't believe in the institutional level, because always there is what you have been saying about the colonialism, about the way these kind of institutions work. For example, we have cases against the Mexico state, cases of crime of state. People have gone to the CPI, and the answer always is no, we won't take that case because it's the Mexican state. It's not. So it's complex, but I believe in the justice of this kind of groups of alternative justice. But the problem is we don't have time. That's the problem.
Yeah.
That's my answer.
Sure. Thank you so much for your contribution. I mean, if you're proposing we start a revolution, I think there's going to be a lot of people in this room that would follow you, Tamara. I mean, okay, we need to be talking. I think we need to be talking in those kind of ways, though, as you say, in transformational ways, absolutely. And I can see a couple of, transformational ways that don't necessarily might use the institutions. That's the debate we're having, but don't rely on those institutions to save us or those environmental defenders that are being murdered on a daily basis, or to save the planet. But I think, Jose, did you want to come in? Because I was going to, if you don't mind, you can come in first on the next point, because I'm going to continue the theme, because I can see, I mean, we have 10 minutes left, but I can see a couple of points in the chat that I want to raise. So Rosemary Coopers is asking, would the concept of common goods be helpful? And Caroline is raising the issue about whether we should be forcibly dealing with the fossil fuel industry. Now, they seem like different questions, and they seem unrelated to Tamara's question, but I think they're very related, because what the questions there are implying that we need some fundamental change in social relationships, in the way economies are organized, in the way that we organize private property, and the rights to produce fossil fuels and so on. So I guess that's my question to the panel, and I think it's a good question to round off, because we've been talking about the possibility of achieving structural change and what that means for an ecocide law. So I hope you don't mind, it's the most difficult question, but the question I want to put to the panel now is do you think an ecocide law would aid in the search for structural changes, fundamental changes to the way that we organize our economy, our lives, our social relationships, our politics, and so on? Is an ecocide law going to help or hinder the need for structural change that we need to change the way our societies are organized? Jose, you get that question first.
Well, the easy one. No, thank you. I just want to, and I think I'm going to try to answer that question, but I want to pick it up from Tamara's point. And I think there is a really important dichotomy between how we think about ecocide law and how do we think about everyday law and everyday regulations, and the way in which environmental crimes, environmental harm operates in daily basis. So I think ecocide law deals with deceptional, with that is extraordinary. And so is crimes against humanity, genocide, etc. It's designed to deal with extraordinary or exceptional cases of crimes or harms that requires intervention by the international community, right, or by the International Court of Human Rights, and that implies a set of colonial and kind of historical practices that are rooted in colonialism. But the my sense and my guess is that in reality, environmental harm and crimes operate in a very routinized daily basis, that of what Nixon called slow violence, right? And it had become common knowledge, right? That thesis of slow violence, right? But in fact, that is quite true. Like the operation of ecocide is invisible in many instances, is daily, is part and parcel of the economy, is parcel of how we carry on our life in everyday manner, right? So how do we deal with that? How do we face that routinized harm, and how we make that so that, I don't know if we need the international community to be addressing that, or if we need different mechanisms or different approaches to what have become normalized, right? And I was thinking about the maroon communities, right, that Tameka mentioned. And I think it's a brilliant example of how this the logic of exceptions, the logic of extraordinary, when it's translated, is applied to those, to the poor, is applied to the racialized, is applied to the communities that does not represent, right, a threat as fossil fuel industry. So I think that is a dichotomy that we need to think, and I don't know if I answer your question.
No, it's
but
clear.
I was just thinking. I was
Well,
thinking on that.
You just raised another question, really, but that's okay. Tameka, do you want to come in on this, Tameka, or yeah,
Sure,
great.
absolutely. So my answer is short. I don't think ecocide law will be, particularly helpful. If market conditions are usually, at least in small island countries like Jamaica, it's market conditions driven by consumer demand in the global north that determine the extent to which environmental resources are utilized. So unless, and it is therefore the global south that's going to be penalized by trying to produce enough to meet these demands. So I don't necessarily think it will help the poorer nations and the nations in the global south. And to Jose's point about reparations, I think that would be particularly helpful for us to start with. Once we get our small developing post-colonial states on a similar footing as those that are more advanced, wealthier, then we can talk about the applicability of law across the scale, across borders. Right now, we're not in the same place. So it would be important for me to know how that law would be enforced. Is it that states are going to be fined? Because if that's the case, then small island developing countries cannot pay. They still are unable to pay back from those financial loans they borrowed in the 80s and the 90s, which is what's causing this cyclical problem. They are poor, they are trying to export, they are taking all the resources that's available to them and putting that into manufacturing goods to export, and here we are. And then they would be punished for doing just that, trying to survive. So the short answer is no, it cannot help now. There is much to be done in terms of equity before we can consider whether or not to implement an ecocide law that's applicable across borders. We're not on the same footing. We're not there yet.
Thank you so much for that, Tameka. Alexis, do you want to come in with some final thoughts? But just before you do, Angela, maybe, because I know some people are drifting off, but maybe you could just post that link again to our mailing list for future events, if that's okay, just so that everyone gets a chance to that. Thanks, Tameka. Okay, Alexis, do you want to make some closing comments?
Yeah, well, in part I gave my answer already. I don't believe that ecocide by itself will create some sort of a structural change, but it could help. It could help to open up the discussion to look for different means through achieving that kind of a structural change. So I'm interested not in the end, not in criminalization in itself, but in the discussions that are around that. And in relation to what Jose said about the exceptionality, I totally agree. Ecocide is showing what is exceptional, the most kind of devastating crimes against nature. But sometimes we can use exceptional to shed light on the normalized, right? As George Agamben says, usually the exception becomes the norm in our societies. And we can use ecocide to shed light on normalized environmental crimes. For example, I don't want to bring again my own experience, but in Argentina, we use the dictatorial state violence to shed light, for example, on police violence, on existing and current police violence, in normalized daily police violence. So you can bring the exceptional to the normal or to the daily, and you can find a lot of connections there, because what creates or what produces ecocide is also producing that normalized environmental and daily damage. So there are a lot of connections that you can explore there. And for me, as I said before, this dichotomy that we open up between saying yes or no to ecocide is not that useful. We can use all the tools that we have to open many discussions and then to see what is helpful or not, but not to cut the discussion from the very beginning.
Thank you, Alexis. Hannah, do you want to make some closing comments? You don't have to, but this is the chance to do so.
I'm just reading all the amazing contributions on the chat. I wish you guys can save that chat, right? So you can preserve the discussion in some sense. I always get worried that Zoom chats just go away.
Good point.
Yeah, I think that we're not going to get to address all of this, but it's really good to have these examples being put up there. And I really appreciated Tamara's framing of what is happening in Mexico right now. I think about it a lot in my own work, obviously dealing with coca and the cocaine industry and in Colombia, and it's kind of like this trinity that is formed between the state, the corporation, and let's say the narco or the illegal armed group. And really, it's not like a separation, right? It's actually a coercion, and it's actually a blending of those three. But yeah, essentially, in order to prosecute it, the state would have to investigate itself, which we've already established it can't do. It's also kind of what forensic architecture's project is, to investigate the state investigating itself. And then you'd have to basically get it to admit this this relation, right? And not just use it as the cloak, as it's also often used, that environmental destruction is often pinned on this nebulous figure of the narco, and that nebulous figure is masking, in fact, that triage, which also includes corporate structures, right? So, yeah, someone put in the Andres Malm example of going back to armed, not even going back, it's still not over, obviously, armed resistance in relationship to environmental destruction. That's a longer discussion, but I think it's very worthwhile. And then the examples of communities that basically remake themselves in the aftermath of war, keeping in mind, ecological justice. So I think the answer is that it's definitely not the state level. If international level could be actually enforced, maybe that's, but then obviously you have the colonial paradigm to deal with. And then someone needs to basically support the ground efforts, or the ground efforts will mobilize and also need to become armed, because this is extreme forms of violence that we're speaking about right now. Not just against the earth, but obviously against the people who are defending it.
Thanks, Hannah. So I'm going to move to Marília now, because she had the first word, and so she gets the last word. I'm not sure why.
Okay.
Yeah,
Thank you.
that's typical. Hi, Marília.
Okay, to answer to your question, well, I think I have already answered. I think that no, that the ecocide law doesn't have this power, all this power. But for me, the problem is not only that. The problem is that it deviates of the main problems. But even if we think about all these things that Alexis talked about, Argentina, for example, I think we are talking about another thing, and I'm sorry that you will not have the time for discussing exactly this point, but I think it's another thing, because in another sense, firstly, the judgments, the trials were not the center of the questioning transitional justice in Argentina, because there are also the thing about revealing the truth, talking about memory, and doing some reparation also. We could see the grassroots movements dealing with something that's much more than punishment. It's about justice. And when Jose Atiles before talked about reparation, I think this is exactly what I wanted to address in the first part of my speech, that is about the modern penal rationality, and how we could move beyond this to deal with other things that are not only punishment. That's about our way of life. That's about the structures of power that permit all this destruction in a daily basis, for example, in Amazonia. And I am saying that because all these grassroots movements that are focusing now in the criminal law, I don't think that it's a problem to, for me, it deviates the main problem, but it's okay. The question is, what are we going to do, for example, with all this mobilization in the moment that we have the criminal law published, for example? I think that this mobilization, this grassroots mobilization, could be exactly a starting point for thinking about alternatives, and all in this transformative way, to think about justice with the very victims, the main victims, directive victims of ecocide. And I'm not talking only about humans, but also about humans in the global South, the indigenous people, the people who depend mostly on nature to survive, to have their culture, to reproduce their culture too. It's not only about the biological life. So how the very victims, the directive victims, and are thinking about environmental justice at this moment. How could we engage with all these people to think about alternatives? That's not only about exceptional cases, but also, of course, but not only about that. That's about something else, because we don't have time, as everybody says. So are we focusing on something that we know that only deviates from our really important target? Or are we using this time we don't have to develop something more creative from a grassroots movement to create something that we can do together, and not to give to an international court that's racist, that has this colonial background and everything, to say what is nature, what is ecocide, to interpret the law, to decide who will be punished, who will not be punished, if they don't have any participation, any transparency. So I think that this mobilization, the grassroots movements, is really interesting, important, and this is what the Stop Ecocide movement is bringing to us. And I think we could think in ways to redirect that, to go further on listening to to other people, to the people who are more directly being victimized by all these problems, and of course to imagine things that go beyond punishment. That's what I tried to think about. Thank you for the floor.
Thank you for saying that so eloquently. Look, I think this is a good point to end on. We have a big movement, a big Stop Ecocide movement, which creates some possibilities. And I have to say, this session has been very important for me for rethinking what those possibilities are. This panel has been really important, and we have it on film, so we can post it for people who want to listen to the discussions and the debates. Because I can't think of a broader and a more wide-ranging and comprehensive critique of the proposals, but also realistic discussion about where that movement might go and how that movement might be built. So thank you once again to all of the contributors for some really fantastic and committed presentations. I do want to just, as we close, say that we're going to have more and more of those events run by the Centre for Climate Crime and Climate Justice at Queen Mary, University of London. Also, I want to recognise that this was also done in conjunction with the IHSS Faculty Climate Emergency Group, and there will be more events. So hopefully you've signed up for them. Part of the work of the centre, we've had a big discussion about reparations and what justice means. This is a new centre, and one of the things that we will be doing is looking at who gets the profits. We're going to be following the money from climate change, following the profits, reaching behind the corporate veil and trying to identify the real investors who are making money from carbon emissions. So it's one contribution. Another contribution I think that the centre will be looking to make to tap into those debates. But we will be up and running very soon, and we will keep in touch with what we're going to do. And we are going to have probably no more events in the summer, but we're going to have a couple of big, high-profile events in the autumn that we will keep you in touch with. But in the meantime, I hope you join me in giving our contributors a big round of applause, because they deserve it for the effort they've put in and for the intellectual richness they've brought to this debate. Thank you very much, everyone. Thank you.